from the main list. Item number 1.
Yes, you have to explain the process to us.
My lord.
How many days? 439 days.
439 days in this case, my lord, and earlier.
Oh, that's not bad. 439 is the 439. Very good.
And 1 year earlier to that, my lord, he was absent for 450 days, my lord.
450 days.
My lord, that is not correct position. 28 days. 2010, there are 2 charges. One for 2010, 28 days. For that, I have been as a leave was sanctioned subsequently and nothing. But 2013, they instituted.
Very good. But in your career, was there a 450-day unexplained leave?
No, 439 days.
No, 439 is this one.
My lord.
Previously, was there any?
No,
There was no.
No.
That's not-
Because at the time of levying punishment, one can take that into account. One will not punish you for that, but one can take your conduct into account.
That
to
is
arrive
not
at
there.
punishment.
That is not there.
My lord, to answer this, my lord, page 107 is my affidavit before the learned single judge, my lord.
107.
107.
Let's finish the factual side, then we'll go into the procedural. Yes, we are at 107.
My lord, the sentence will be start from the previous page, my lord. The General Assam Rifles Court, GARC, has been ordered based on the gravity of the offence. Para 16, my lord, the third sentence, in fact, my lord. The General Assam Rifles Court, GARC, has been ordered based on the gravity of his offence, as the petitioner was a perpetual defaulter and he absented himself for 3 times. 450 days with effect from 24/1/2007 to 17/4/2008, 28 days with effect from 9/9/2010 to 6/10/2010, and 439 days with effect from 5/3/12 to 16/5/13.
Did you use an affidavit in reply?
The file affidavit. That starts at page 120.
That's at page.
Starts at 120, page 120. The answer to para 16 is at page 11, my lord, para 11, my lord, page 123, para 11.
So there is admission. There is admission.
There's no denial to that.
No, there is admission. The deponent under compulsion remained absent from duties, and in each occasion the deponent informed the competent authority regarding illness of his mother. So that's admission.
Well,
Yes. Tell us the procedure.
my lord, the procedure, my lord, in the present case, he has been charged under section 26 of the Assam Rifles Act, my lord.
He was charged under.
Section 26. Says, my lord, any person subject to this act who commits any of the following offences, that is to say, absents himself without leave or without sufficient cause overstays leave granted to him, Then coming to the punishment part, my lord, in clause Z, shall on conviction by an Assam Rifles court be liable to suffer imprisonment for a term which may extend to 3 years or such less punishment as in this act mentioned.
So you have to show us that removal from service in lieu of imprisonment is a lesser punishment.
My lord, then Lordship will kindly come to page section 57, my lord. It lists out
He
the,
has been compulsorily retired
my lord, clause D, my lord. Whereas,
according to scale following.
my lord, whereas he was liable for clause B, my lord, imprisonment which may be for the term of life or any other lesser term, but excluding imprisonment for a term of not exceeding 3 months. So life up to 3 months, my lord, will be covered under clause B.
Yes.
Less than 3 months will be covered under clause E, my lord.
E. For a term not exceeding 3 months.
My lord. My lord, thereafter, my lord, section 58 says, my lord, well, before that, 57 subsection 2, my lord, it says, each of the punishments specified in subsection 1 shall be deemed to
Yes. That's done. That's
scaling.
one it says according to scale
My lord.
following. So that is superfluous.
My lord. Section 58 says, my lord, that punishment can be given or lesser punishment.
Provisions of the unauthorized rules court may, on convicting a person subject to this act or any of the both inclusive, award either the particular punishment of which is stated in the said sections or in lieu thereof any other punishment. So section 58.
My lord. So, my lord, statutory provision
It was tried by an Assam Rifles court.
Assam Rifle Court, my lord.
Very,
General Assam Rifles Court.
very good. Now come to the factual position. Show us the notice. Notice meaning charge sheet.
Well, before that, if Lordship permits, I just want to show one decision, my lord, to say that the scaling, the punishment mentioned higher, my lord, will be higher in gravity, my lord.
No need. It's obvious. 57(1) and 2 both say it.
So the Lordship will last occasion put a query that maybe you would have preferred to go for imprisonment for 3 months and come back to service, my lord.
57(1)(2) says it clearly. Says according to scale, and if there is any doubt, 57(2) says it.
Right.
Yes. Come to the charge sheet, please.
Charge sheet is page 112, my lord.
First charge is how many days?
28 days.
And the second charge is 439.
439.
Reply?
My lord, this is a trial, my lord. Trial by Assam Rifles Court. So reply is not provided for in the rules, my lord, because it is a proper court, my lord. Charges are framed and thereafter witnesses are examined, my lord, and judgment is passed by the Assam Rifles Court, my lord. My lord,
Any written representation by him?
my lord, the only requirement, my lord, that trial by a court martial, my lord, is a sort of court martial, is preceded by court of inquiry and summary of evidence, my lord. That the provisions, my lord, Section 184 of the Act, my lord.
Section or rule?
Section, my lord, of the Act. 84.
184.
84.
Oh, 80.
Oh, 84.
We got 184.
We had 184, exactly.
Sorry.
Inquiry into absence without leave.
My lord, a court of inquiry. So, my lord, in this case, court of inquiry was conducted, my lord.
Be assembled and court of inquiry shall be assembled and a court shall inquire respecting the absence and satisfied that without due authority court shall declare thereof in the prescribed manner. All right.
Well, court of inquiry is a fact-finding inquiry, my lord, whether he absented and
Whether there was sufficient cause.
sufficient cause, my lord.
Then the commandant shall make a record thereof in the prescribed manner.
And he can recommend whether further proceedings are required or he can drop at that stage also.
Where
my
do we
lord.
find that?
For that, we have to come to rules, my lord. Rule 183. My lord, court of inquiry is followed by summary of evidence, my lord. Rule 49 and 50, my lord. Rule 49 and Rule 50. My lord, first court of inquiry is held, my lord. If prima facie case is made out, my lord, then the competent authority directs for recording a summary of
So
evidence.
we come to 49.
49. My lord. Forty-nine and 50, my lord. Sub rule 4, my lord.
Very good.
54 provides for furnishing a copy of the report to him, my lord. My lord, in the present case, page 109,
Evidence has to be given to him.
my lord.
Abstract of evidence. has
Abstract
to
of
be
evidence to given to him, my lord. My
given.
lord,
And then he has to be given more than 24 hours to make his statement.
my lord. My lord, in the present case, my lord, page 119 of the paper book will reveal that the court of inquiry as well as abstract of summary of evidence was given to him, and he has received that, my lord.
Page 190.
My lord. Court of inquiry for 28 days, court of inquiry for 439 days.
Yes. Then
He received it, my lord. He participated in the trial, my lord. He was present during the trial, and the entire formality that was required by the GARC to be followed, they followed.
Then what happens after? Well, what does 51 say? Disposal of case after recording.
Of summary of extract of evidence. But it says, my lord, commandant, after some abstract is either dismiss the charges if there is no material found, my lord, dispose of the case summarily, refer the case to the competent superior officer for disposal, or remand the accused for trial by a force court, my lord. So here, clause D was
So
taken
he,
recourse to. He was sent for trial by the GARC, my lord.
by a force court.
My lord.
And then what does the force court have to do?
But force court framed the charges, my lord. I pointed out at page. Page 112, my lord.
So 112 was not before the thing.
No, my lord. When the matter comes to court, my lord, before that, my lord, there is a tentative charge sheet.
Where is that?
That you will find that.
Page 66, my lord. Tentative charge sheet, page 66.
Tentative charge sheet is at?
66.
Page 66,
Page 6.
dated 31st August 2013. August 2013. The main charge sheet is after about 1 year, my lord. That was dated 12th September 2014.
Where is that?
Page 112. my lord.
112 is dated 29th August 2014.
August.
Okay, and after this, Court of Inquiry took over, force court took over,
My lord.
then what happened?
My lord, witnesses were examined, my lord,
by the force court.
by the force court.
And then is it required to follow any procedure? Where is the decision of the force court?
Decision not there. The decision never communicated, only, my lord, intimation was given. They found guilty, intimation was given, page 93.
Where is that?
Page 93.
115.
Page 93, your lordship.
93.
Yes. This findings and opinion was never served. Actual order of penalty was not served. There are three, my lord. Confirmed by the confirming authority. Actual order of penalty was not served. And appeal also.
Just a second. First, what the force court is supposed to do?
My lord, in the rules, my lord, from chapter 10, rule 68 onwards, my lord, provide the details.
See it onwards.
My lord.
Commencement course. Come to 107. The finding on every charge upon which the accused is arraigned shall be recorded and except as provided in these rules shall be recorded as findings of guilty or of not guilty.
My lord.
After recording the findings on each charge, the court shall give brief reasons in support thereof. The law officer, or if there is done, the presiding officer shall record brief reasons and proceedings. Said record shall be signed and dated by the presiding officer and law officer. When the court of the facts proved do not disclose, forget it. Court is down to the judge. The facts which final proof evidence differ materials, special finding, forget it. The findings on each charge shall be announced forthwith, 11, in open court as subject to confirmation. Then 109 is procedure on conviction. If on finding any charge, then the guidance in determining the sentence of confirming authority in court before deliberating on the shall, whenever possible, take evidence of record and general character, age. Then 112, the sentence together with any recommendation and the reasons shall be announced forthwith in open court, and the sentence will be announced as subject to confirmation. Upon the court awarding the presiding shall affix a signature date, and such authenticate report of proceeding signed shall be transmitted for confirmation. Where are those records?
Or page 93 will indicate, my lord, of the paper book. Page 93.
93. Confirmation, just a second, let's finish the root part of it. Receive the then promulgation is 116. When confirmed, send the record of the commandant for prolongation to the accused charge finding sentence. Fact of prolongation shall be recorded. Appendix 11.
From mitigation submitted. From mitigation plea submitted is submission.
Yes.
That means that.
And where is the appeal provision? Where are the reasons? Why are those reasons to be recorded if you haven't produced them?
My lord, what happened, my lord? The writ petition was framed only on the ground that CCS, under CCS rules, my lord, that copy of inquiry report was not given to him, and which was in violation of Karunakar case, my lord. The entire tone and tenor was set on in that line, my lord. So this was not this. We didn't feel it necessary to, because there were no such pleadings also that reasons were not recorded or he was not tried by GARC. My lord, even in the grounds of appeal, my lord, in the present appeal, lordship will see they are only alleging violation of SL versus Karunakar, which deals with CCS inquiry, my lord, of civilian employees, my lord. Because I was before the learned single judge, I argued the matter, my lord. That was the only case, my lord.
My lord, I'll make a very short submission. Lordship, our whole case before the learned single judge, my lord, that we have not been served with a copy and there was no findings anywhere in the communications. Only I have been communicated. Actual penalty order I have not been communicated. Actual appellate order I have not been communicated. Even, my lord, I'll take to your lordship first page 91, your lordship, mitigation plea. Page 91 of the appeal, lordship. Mitigation plea. There, my lord, I have produced the medical certificate. Because of my mother's serious ailment, I could not rejoin the duty. I have submitted. That is on record, my lord, in the mitigation plea during the trial of the court. Then your lordship will find in the penalty order, page 93, your lordship, only the confirming authority has confirmed the penalty. I have been found guilty. That has been communicated. No reason is there, my lord.
Very good.
No reason is
Come
there.
to page 99.
My lord.
That is your appeal.
My lord.
Where are those points taken in your appeal? Where are any of these grounds taken in your appeal? The domestic appeal. If you are complaining of irregularity, you should have pointed out at the domestic appeal. In the domestic appeal, all that you say is paragraph 5. Disabled person did not take cognizance of compelling circumstances and justification.
That is there, my lord. That is there. And my lord, there is only one thing, my lord, if your lordship permit me, my lord. Because there must be a finding that my absent of abstained leave is willful. Willful, my lord. That finding must be there.
That is taken for granted. It's such an obnoxious,
My lord.
It's such an obnoxious offence.
My lord, in ECL case, also says that even if it is not there, my lord, in the charge, in the
Necessary. Yes. The appellant herein has suffered a punishment of compulsory retirement passed by the General Assam Rifles Court for the appellant having overstayed his leave without sufficient cause for a period of 439 days. Full stop. At the relevant point of time, the appellant was an assistant commandant, bracket MO, in the force, small f, paragraph. The primary grounds canvassed by the appellant in the writ petition directed against the order of punishment and the appellate order rejecting the appellant's appeal were that the principles of natural justice were not followed, in the sense that no copy of the inquiry report or no finding of the disciplinary authority agreeing with the inquiry report was forwarded to the appellant. It is apparent on a plain reading of the writ petition that the approach of the appellant herein was as in disciplinary proceedings conducted in civilian organizations where an inquiry officer is appointed before whom the delinquent has a chance to rebut the evidence against him, following which the inquiry officer's report is dealt with by the disciplinary authority, whereupon the disciplinary authority issues a notice to the delinquent, upon satisfied with the evidence against the delinquent, to proceed to award some form of punishment from the delinquent. Full stop. To the delinquent. In such disciplinary proceedings, the delinquent has a chance to adduce evidence to counter the charges leveled against him before the inquiry officer, and has a chance to persuade the disciplinary authority to not agree with the findings of the inquiry officer full stop. Both at the inquiry stage and at the punishment stage, reasons are required to be recorded, and the delinquent is served the inquiry report and the reasoned order of punishment. Full stop. Paragraph. In the ordinary disciplinary proceedings, in any civilian organization, in any civilian government organization, the disciplinary authority, upon receipt of the report of the inquiry officer, has several courses of action open. Full stop. First, the disciplinary authority may completely disagree with the inquiry officer's report and find that the evidence on the charges to be completely lacking. Full stop. In such a case, the disciplinary authority does not have to forward the inquiry report to the delinquent, but he merely closes the disciplinary proceedings and informs the concerned employee accordingly. Full stop. Secondly, the disciplinary authority may prima facie, agree with some of the findings and, prima facie, disagree with some others, and may require the inquiry officer to reconsider the matter upon notice to the delinquent. Full stop. Thirdly, the disciplinary authority may, prima facie, agree with some of the findings and, to such extent, call upon the delinquent to show cause why he should not be punished in such regard, full stop. Finally, the disciplinary authority may, prima facie, agree completely with the inquiry officer's findings and refer the inquiry report to the delinquent as to why the findings should not be upheld and the delinquent appropriately dealt with. Full stop. However, in a discipline force as any central armed police force, the procedure for conducting disciplinary proceedings is laid down in the statute governing such force or the rules framed under the governing statute. Full stop. It is not necessary that every report or every finding be communicated to the delinquent. Full stop. There are checks and balances to ensure that the findings rendered are confirmed by a superior official. Full stop. The emphasis is on discipline being maintained in a discipline force and, as long as the delinquent has been heard on the charges and findings are rendered which are confirmed by a superior official, the procedural integrity is maintained. Full stop. Paragraph. The discussion in this case need not have been as long as it is, since the appellant herein was charged with unexplained absence of from duty for 439 days, and his justification therefore was the apparent illness of his mother. Full stop. On the face of it, the matter appears to be so absurd that it can be hardly expected of a disciplined force to accept such excuse, unless exceptional circumstances are cited. Full stop. Paragraph. It must also be said, at this stage, that in that the scope of judicial review is limited here to procedural fairness and an inquiry as to whether the delinquent in this case had an opportunity to defend himself. Full stop. This court, in exercise of its jurisdiction under Article 226 of the Constitution, does not sit in appeal over the decision of the disciplinary authority and does not go into the sufficiency of the reasons in such regard. Full stop. A tentative charge sheet was served on the appellant on August 31, 2013. Full stop. He was charged under Section 26 of the Assam Rifles Act 2006 for unexplained absence from his post. Full stop. 2 instances of absence without justification of 28 days and for 39 days were cited against him. Full stop. There is no dispute that the appellant herein was aware of the charge sheet and participated in the proceedings, ultimately before a court of inquiry. Full stop. Indeed, the appellant herein availed of every opportunity available under the statute and the rules framed thereunder to furnish an explanation and get away with the same. Full stop. The appellant applied for mitigation in terms of Rule 115 of the Assam Rifles Rules 2010. He also preferred an appeal before the Director General against the promulgation of punishment that was issued on January 5, 2015. Full stop. In course of his appeal to the DGAR, the substantial ground is captured in the following paragraph, next line, open quote, small v within bracket. The disciplinary proceedings did not take the cognizance of compelling circumstances and justification submitted by me for my absence and sentenced me to a harsh punishment of compulsory retirement, full stop. The quantum of punishment in this case exceeds the natural justice. Full stop, close quote, paragraph. What cannot be missed is the complete failure on the part of the appellant herein to complain of any procedural irregularity or any prejudice suffered by the appellant as a consequence thereof. Full stop. Though at this stage, in appeal against the writ court's order, some specious grounds have been sought to be raised as to the reasons for the punishment not being furnished to the appellant, the appellant was aware of his rights in accordance with the statute and the rules governing him, and at the time of his domestic appeal, the appellant did not raise such grounds. Full stop. As a consequence, the appellant is estopped at this stage from complaining of any procedural irregularity or the lack of reasons for his punishment being furnished to him. Full stop. Paragraph. In any event, even upon a trial being conducted by an Assam Rifles court, there does not appear to be any specific provision in the statute or in the rules for furnishing the reasons to the delinquent. Full stop. It appears that reasons ought to be recorded by a force court, F capital, for the purpose of the confirming authority being persuaded to confirm the punishment proposed or recommended. Full stop. There is no dispute that the confirming authority in this case duly confirmed the punishment recommended by the force court, and such punishment and the nature of such punishment was communicated to the appellant on January 5, 2015, which prompted him to prefer the domestic appeal on or about February 2, 2015. Full stop. A ground that has been taken, now one of the grounds that has been urged by the appellant is that the punishment was not commensurate with the nature of the offence complained of. Full stop. It is the further case of the appellant that not only was the punishment harsh, such a punishment may not have been permissible since section 26 of the Act, under which the appellant was charged, provides for a punishment that may extend up to 3 years in 3 years in prison. Full stop. Paragraph. On behalf of the respondents, copious references have been made to the statute and the rules framed thereunder, including section 57 of the Act and the scale of punishment set down in subsection 1 thereof. Full stop. To boot, section 57 bracket 2 of the Act provides that the descending order of punishment, in terms of its harshness, is indicated in subsection 1 of the provision. Full stop. Since the punishment of compulsory retirement in this case is found at section 57 1D, it's a lesser form of punishment than imprisonment, than a term of imprisonment of 3 years, which is covered by clause B of the same provision. Full stop. Section 58 of the Act permits an Assam Rifles court, on convicting a person inter alia under section 26 of the Act to award the particular punishment with which the offence is stated in the relevant section provision, or in lieu thereof, any of the punishments lower in scale set out in section 57 of the Act. Full stop. For several provisions from the rules, comma, including the procedure to be followed of recording evidence by a court of inquiry and the procedure to be followed by an Assam Rifles court have been placed from the rules, comma, there does not appear to be any merit in the general assertion of the petitioner that the procedure was not followed or that any prejudice has been occasioned thereby, has been occasioned to the appellant as a consequence thereof. Full stop. Paragraph. Apropos the appellant's assertion that he was not given the relevant documents for him to either defend himself or understand why he has been punished to the extent that he has been, comma, the respondents referred to a receipt of October 17, 2014, comma, a copy whereof appears at page 119 of the appeal papers. Full stop. It is the undeniable position, comma, from such receipt that the appellant herein was duly forwarded the inquiry reports pertaining to his initial period of 28 days absence and the subsequent period of 39 days absence, full stop. In addition, comma, the summary of evidence in respect of either charges, the summaries of evidence. Now, the summary of evidence in respect of either charge was also forwarded to the appellant and duly received by the appellant. Full stop. The respondents also referred to a previous occasion where the appellant was absent without justification for a further period of 450 days sometime in 2007 and 2008, full stop. Though some minor punishment was suffered by the appellant for such long absence without justification, comma, the Assam Rifles Court and the confirming authority were well within their rights to consider the general conduct of the appellant herein in absenting himself from his post without sufficient cause, full stop. As a consequence, comma, the punishment of compulsory retirement awarded to the appellant does not shock the conscience of the court, comma, since the appellant was employed by a disciplined force, full stop, paragraph. The judgment and order impugned dated
December 2022.
December 1, 2022 has taken all relevant considerations into account, full stop. It is evident on a reading of such judgment that the primary thrust of the appellant before the writ court was the procedure which was required to be followed in view of the judgment reported at 1993 4 SCC 727 bracket managing director, comma, ECIL versus B Karunakar bracket close, full stop. Since the procedure in respect of Assam Rifles is completely different and is not covered by the CCS rules, and is laid down, and is, laid down in its independent statute and the rules framed thereunder, the reference to the Karunakar case was completely misplaced, full stop. Paragraph further, as noticed above, the grounds sought to be urged in the writ petition were never canvassed in course of the domestic appeal, full stop. Paragraph, there is no merit in the appeal, and the writ court was perfectly justified in dismissing the petition and leaving the appellant to his fate, full stop. Paragraph, appeal number so and so is dismissed. Since the appellant has lost his service, he is spared the costs that he richly deserved in carrying this unnecessary appeal. Full stop. Not unnecessary, eminently avoidable appeal. Yes, take back your.
But there was a delay, madam. That.
Right in the beginning, in view of the good ground shown, the delay of about however many days is condoned and the appeal is taken on record, paragraph, the appeal is taken up for immediate consideration. I just wanted to make that clear because there's something.
Any mention for unlisted matter?
We crave your lordship's indulgence, my lords. Lords, we're making mention for moving an unlisted matter, my lords. It is a PIL concerning, my lords, the Pine Mount School in Shillong. My lords, a 150-year-old heritage structure is being demolished, my lords, and that too in the middle of an academic season.
When was it demolished?
It started from Friday evening, my lords.
Very well, tomorrow? Give notice?
Tomorrow, my lords,
Oh, tomorrow is a holiday.
my lords.
Give notice to the school, come back at 2 o'clock.
My lords. Obliged.
But the school must be here.
Is the state, my lords, is the state of Meghalaya, my lords?
State runs the school.
My lords, we'll do that. Highly obliged.
From the Mingus, item number 1.
Both matters, in view of the embarrassment to one of us, B. Bhattacharjee J. Mama, let this matter be placed before another bench. Same order in both matters.
Both matters, my lord? Great. Thank you.
Oh, I reminded him. When is it? Not this